Welcome. So in case you're wondering, we're recording as a webinar, so hopefully we'll be able to put it up on our website in case any of your colleagues missed the program and are particularly interested. They'll be able to hear the video, hear the audio, and see the slides as we go through. I'm Sue Golden. Welcome to Venable. Welcome to this program. We're really excited to have these terrific speakers here today with us. Just a little bit of background information about the program today. You should have copies of materials and an outline with CLE information. So we've got citations to some of the things we're going to be talking about. The program is approved for 1.5 hours of credit, so remember to sign in if you haven't already on the registration desk out there by the entryway. There's an evaluation form in the materials, and we welcome your comments and suggestions for future programs. Also in the handout are bios for our speakers, which I'm also going to go through, and a short overview of our real estate practice. And we will have time for some questions at the end, hopefully. And you can also email us. Our email contact information is in the materials if you have any other follow-up questions that we don't have time for. So, streets. I would like to welcome Kelly O'Brien, who is with the Brooklyn Borough President's Topographical Bureau. She started there in 1990 and has worked her way up to become the office manager of the Bureau. And she's going to tell you a little bit about the specifics of what she does, but basically she monitors all the work in the Bureau, assists with research, house number assignments, legal street status information, and ULURP and other approvals that need to go through the Borough President's office. And then here we have Michael Roberts, who is the Chief Operating Officer and General Counsel of Royal Abstract. Royal Abstract has been at the forefront of the title insurance business since 1946, and they provide a vast range of real estate and title services nationwide. He's been there since 2014. Previously, he was, and still is a lawyer, he was with Paul Weiss. Joe Pacina is an associate here at Venable in the real estate group. We work closely together, and as I said, I'm Sue Golden. I am counsel in the real estate group, and I have had many questions about streets over the years that have come up, and just in torturing Joe with various research questions, decided that it was about time for us to try and get a complete picture of some of the issues that we have faced. And I have to say, in putting together this program, I came to realize that you really need all these different areas of expertise to get a good, complete picture of street issues. You can't just look at the legal, you can't just look at the title, and you can't just look at the map. So we sort of luckily fell into just the right group of people to talk about some of these issues. And I hope that we will answer some of your questions and give you guidance on where to find answers to the ones that we don't get to. So we're going to talk about sources of information about particular streets and how to research that. We're going to talk about understanding the language of streets, public, private, mapped, demapping, dedication. We're going to clarify some jurisdictional and liability issues and give an overview of some of the rights that private parties can get in city streets. But first, a little bit of history. Joe's going to start us off.
Hi, everyone. So in Manhattan, it's pretty much impossible to talk about the streets without talking about the grid. The street grid is a product of something called the 1811 Commissioner's Plan. In 1807, the Common Council, which was the predecessor to the City Council, reached out to the state legislature for help in planning future streets in New York City. While the city already had jurisdiction over all the land not previously granted or sold to individuals, the city's powers to determine street width and alignment were less clear, and over time their conflicting maps have been produced, and this resulted in a lot of controversy. So the state legislature responded to City Council's request by creating a state-appointed commission with the full power to establish a binding plan for future streets and open spaces, and passed a statute that gave the commissioners exclusive powers to lay out the streets and squares between Houston Street and the north end of Manhattan. The main streets were to be no less than 60 feet wide, and no street was to be less than 50 feet wide. The city was charged with carrying out the plan, and it was understood that it could not deviate from the plan without specific legislative authority. The grid you see here is a drawing of that commissioner's plan. And outside Manhattan, the street layout in the 5 boroughs was most prominently affected by the consolidation that occurred in 1898 of all the boroughs into one city, the city of New York. And in anticipation of that consolidation, many streets were redrawn to sort of conform with the grid. Some streets did not make it onto the new maps, and there's one well-known example that Kelly reminded us about. It was called the Road to Lott's House, and this road it's in Canarsie, and the road is one of many farm-to-market roads that predated the grid. So after consolidation, the road still exists today, but it doesn't appear on any city maps.
And it's not necessarily a road that you can actually sort of follow and drive down, but there are pieces of it that are still there that are not, necessarily part of the adjoining properties. So it's kind of an interesting little historical fact. This discussion about the road to Lott's House seems to be a good entry point for starting the discussion about the status of streets and the language that we use to describe streets. So Joe's going to start us off from the zoning resolution.
The definition of what's considered a street for the purposes of zoning is quite broad. Obviously, there are map streets, which are considered streets under the zoning resolution, but other so-called ways are also considered streets under the definition contained in section 1210. A way connecting two map streets may be considered a street if it meets certain specifications, and certain open areas and even some covered pedestrian spaces could be considered streets for zoning purposes if approved by the Department of City Planning. It's important to understand that the ways and areas that are considered streets for the purposes of zoning, under the zoning resolution, because the zoning resolution contains many provisions which regulate the bulk and design of developments that based on a property's relationship to the abutting street. In some zoning districts, the height of a building can be limited based on the width of a building's street wall, and in many other zoning districts, a property's location on a so-called narrow or wide street has a direct impact on the bulk and height of any as-of-right development on that site. A narrow street is defined in the zoning resolution as any street less than 75 feet, while a wide street is any street that's 75 or more. And the official width of a particular street can be found on the city map. Recently, we looked at a property that was located in the special Midtown zoning district, and under the regulations in that district, the maximum height allowed for the building's street wall depended on the width of the street upon which the property was located. So there was a scale, basically, that provided the maximum height the street wall could be before setbacks would be required. And that's just one of the many regulations in the zoning resolution that can have an effect on the type of building that could be built on a particular site.
The word street comes up quite frequently in the zoning resolution. Just in the definition section, it was almost 200 hits. So it's a really important consideration, and obviously something that is, to some extent, property or district specific. So something kind of worth keeping in mind. This is a sheet from the official city map in Brooklyn that Kelly sent to us. The general city law authorizes the city to establish the map. The Department of City Planning has custody under the charter, but if you want to see a current map or get a copy of it or research the history, you would go to the Borough President's Topo Bureau, and you would see Kelly. So Kelly's going to tell us a little bit about what she does and what she can help you with.
Hi. Basically, what I do in the Borough President's Office Topo Bureau is that we maintain the map of the Borough of Brooklyn. We are charter mandated to do that. We're also charter mandated to assign addresses. We also provide surveyors with monument and benchmark information in order for them to do their jobs. We also assist people, with their, questions regarding maps legal status of the maps, and the history, the focus on this topic. And the maps that we have available, we have about 30,000 maps in our office, going back to the 1800s to when the streets were originally laid out for the borough, and then onward to the present as the map changes with streets that have been added and demapped from the official city map. We show all legal dimensions of the street, the grades, the widths of the street, which include the sidewalks, which is very important to know. And that's, that's topo in a nutshell. So.
Great, thank you. So we've started to use the language of the streets in some of these discussions, and I wanted to get a little bit more into kind of what some of those words mean that we've started to use. So it may seem obvious, a mapped street is on the map, right? But you might be surprised at what that information tells you, and even more importantly, what it doesn't tell you about the street. So Kelly, again, is going to tell us a little bit more about mapped streets.
Okay. The map that's shown on the screen is a final section. If you're familiar with Brooklyn, it's the Brighton Beach area. Anything that's in solid lines is a mapped street, and a good majority of them are titled to the city through various means. I think that's discussed a little later. Status. You'll also notice that streets are dashed lines, and those are what we call unmapped streets. And basically, this is what you would come in to get from our office. And basically, if it's mapped and titled, the city has ownership and will maintain the street, and it's open and in use to the public.
So can you tell us a little bit about what a paper street is?
Sure. A paper street is a street that is legally on the map, but physically not on the ground. For whatever reason, the development of that particular area, maybe it didn't make sense for the street to be physically built, or maybe it was built at one time and they just abandoned, I guess you would say, they could abandon it in a sense, where they kept it mapped, but instead of officially demapping it, they just left it there, and it's not used physically. Additionally, we have the dashed lines, which I indicated before. They are they don't have any dimensions, because what our office did was they're showing them as in use and on the ground. To some degree, that might change in other areas where those unmapped streets have actually been built over. So, everything can change. But basically, the streets in this area, the Bright Third Place, Fourth Place, Terrace Lane, anything that's dashed is unmapped, and the city does not have title to those streets.
And then I guess there can also be instances in which a street is mapped but not owned by the city.
Correct. When a street's mapped but not owned by the city, once the city, if they wish to obtain title for maintenance purposes, then we would obtain a dedication to those streets in order to provide the city with an easement in order to go and maintain that street with, paving, basic sewer and water work and information, work like that.
So there's no requirement that a private street be shown on the map. So you can't eliminate the potential existence of a street or a way just because it's not shown. It's just either it's mapped or it's something else.
Right.
Yeah,
I was going to say, and another point on that is that these issues may sort of seem like something that, would come up once in a blue moon where, you're looking at a property and there's a dirt road in front of it or no clear access. But something else that comes up a lot in title is that there's a difference between where a street actually is and what the city has the right to build on it. And if you look at the tax map, this is Metropolitan Avenue in Queens, actually. The solid line on Metropolitan is where the street actually is. The dotted line is where the mapped street is. So the city technically has the right to expand that street. Now, there are existing buildings on this block, so for practical purposes, there's no real current issue. The city is, politically would never be able to get all these landowners to demolish their buildings to widen Metropolitan Avenue. But these are things that need to be taken into consideration if you're planning a redevelopment of a site, or if there's a casualty down the road, the DOB may not let you build in what is effectively the bed of a mapped street.
So as Kelly mentioned, if a street is mapped but not owned by the city, and the city is maintaining it, it's usually been dedicated or could be dedicated. Dedication is based on the common law of prescriptive easements, but it does not necessarily mean that the city owns the street once the dedication is complete. Dedication establishes a basis for the city to use public funds to maintain the street. And Kelly, I guess maybe you can walk us through what some of the guidelines are. And
a dedicated street, yeah. Basically, as Sue said, we have a map street that the city does not have title to. They want to obtain title. They, as a city agency, they come to the borough president's office, and then we look at the ownership of the street in the sense of the abutting owners. If no interest is shown into that street, we'll dedicate it. A good portion of the time, since it is a map street, and most likely it's a through street, it will be in use to the public for 10 or more years. It's been paved, it has sidewalks, it has curbs, it has sewer and water, and street lights, and anything that you would typically see on a street. There are times when we've been asked to dedicate unmapped streets, and those, as you, the private owner, if you wish to have an unmapped street dedicated, you have to go to DOT, because only a city agency can request to have the street dedicated. So then DOT would then contact us, and then the same process happens again. We look at it. If we show, we see that there's interest into the street by the abutting owners, then we will have to stop. We stop and we take a look to see who exactly are these owners, what interest do they have, and how far do we need to go to dedicate that street if we need to, or if we just tell DOT, nope, we can't dedicate it, the abutting owners have interest. Now, in essence, it's private property, and we can't dedicate private property.
So getting the city to accept title to a street is really not that easy. In addition to the maintenance and repair obligations, the big issue is the potential for there to be some existing environmental contamination and liability that the city does not want to accept. So dedication is another way for the city to take over the maintenance without taking on the liabilities of actually owning the property. Sometimes even when there's no history of contamination, if it hasn't been documented, I would say DOT is just really sensitive about taking that on. It's kind of become a big concern of theirs. So I think with dedication, there's that opportunity for the abutting property owners to sort of come in, request that the city take over the maintenance, and if there's enough of a history to justify and enough of a public use to justify the city spending public funds in that way, then through a process, which we actually is not a process that is particularly well documented, so that's why we asked Kelly for, what are the guidelines, but it's a process basically of, kind of researching the history of the street and taking into account some of the factors that she mentioned to decide whether or not the public use is sufficient to justify that level of city support. And I guess the other point is in this discussion of mapped versus unmapped, what you're hearing is that ownership of the street does not necessarily match up with either mapping or with city maintenance. So on the ground, you're just standing there looking at a street in front of your property or wherever, you may have no way of knowing. Is it mapped? Is it unmapped? Is it privately owned? Is it city owned? Is there some mix of ownership? Does anybody have an easement? And I just wanted to ask, I think there's some combination of research that needs to be done with both someone like Kelly and someone like Mike to come up with the answers to those questions. So Kelly's going to start us off on the what they call the those are her dash lines in case you wanted a close-up. What did I do? There we go. That's her status map. So why don't you tell us what that is? And
Sure. Basically, it's a map, the street map, and what we show on here with the colors is how status was obtained for the city. The red is what, simple terms, is legally open. More official term is title vested, or title, confirmed, things of that nature. So it means that the city condemned the property and then took full ownership of that street. Anything that's blue is a cession. What happened is it was owned privately, and then the city, the owners decided, well, we no longer want to maintain it. So we want the city to maintain it. So what they did was they deeded their portion of the street to the city. And in doing that, everybody on the block agreed, we're going to deed everything to the, sometimes you can't really have somebody who's going to, say, oh, I don't want to deed my piece, then kind of, city's not too thrilled with that. They'd rather have the whole street. But a cession also allows the city to have full ownership. I believe there's green on here. There's some green over Sheepshead Bay.
Those darker areas.
Yeah. Oh, thank you. So there's some green, and green is an old road. That old roads go back to Dutch and English times. So we're talking 1600s and 1700s, 1800s. And then we have some, which is indicated on here, but yellow. We have yellow if you come to our office, which are the dedications. And we'll have some dedications that are not early 1900s, and then most of our dedications are 1980s, 1990s, because they were more common back then. And through the dedication, again, we did the research, and we made sure that the abutting owners did not have interest to the property, and DOT was willing to accept the street to maintain that.
And then can you also tell us a little bit about why a street might be unmapped and or not in city ownership?
Okay. Street may be unmapped because the abutting owners have interest into the center line. And if you look at a tax map, it's all, you don't even see a street on a tax map. So they have full interest to that street. The original developer gave ownership to the abutting owners. So they gave, everybody owns their little half of that street. And it might be in their deeds to indicate that. The original developer only gave them ingress and egress rights. The original developer still retained ownership of the street dead, and you as the owner can only go use it for in and out of the property. He created a right-of-way. And again, this, in theory, should be in the deed, indicating ownership, whether it be ingress and egress, or that it's a right-of-way for everybody to use. Everybody benefits from that right-of-way.
And a lot of these, just about all of these things you would discover through a combination of things. But
Right.
Looking at the city tax map to see what's actually in those records is showing where the street ends and where private property begins. And of course, doing a title search through which you'd look at the prior deeds, see what was conveyed, look at the meets and bounds of what portion of the property is actually being granted, and whether or not there are any rights under other agreements that are being conveyed along with the physical property itself in terms of egress and egress, and whether there are maintenance obligations that survive and who owns the development rights. In a deal I had worked on quite a while ago, this actually was a really important issue because determining whether a road is private or public impacts the amount of zoning rights and air rights you have to develop. And on this particular project, the city was originally positing that these were in fact city streets, and they were able to be convinced that in fact they were private, which gave the owner of the surrounding private property a huge windfall and gave them a tremendous amount more development rights than they had before, because development rights are based on footprint. And so they were able to take advantage of the footprint for all of the land that was arguably private versus public street.
So what Mike is saying is it's worth doing the research.
Yeah.
This slide shows a private street that's not mapped. It's partially owned by two separate owners. So this is from the tax map, as Kelly said. There isn't necessarily an indication of a street here. You see there's a reference to an alley easement. But it doesn't look the way a street would look on a tax map, because it's privately owned, so part of it is owned by the owner to one side, and part of it is owned by this owner with the blue-colored property. Another thing that I just wanted to mention on here, at the bottom corner, you can see these words street widening next to this dashed line. So that is an indication that the city has retained an easement there for a future widening of the street or sidewalk to be built. In this particular case, there were no sidewalks, or not wide sidewalks, so they wanted to have additional space to potentially build, which impacts on where the owners can actually site buildings on this property, because they can't cover up that area. As Mike said before, if you've got buildings built, it might be for the future, but in this particular case, there wasn't anything built there, and the development needed to be set back to allow for that future possibility of a widening or a wider sidewalk. And I think the point here is when you see a map or a survey, if you're analyzing title or you're looking at some of these documents, if there's a little note of any kind, or a dashed line or a solid line, pay attention to it, because the street issues are complicated and they can have real impacts on value and on development. So it's always worth doing the research. I don't know, you want to tell us a little bit more about how these things might be identified in a title report?
Yeah, well, so easements and the like will usually show up either in separate easement agreements or in the deeds themselves. Sometimes when owners are granting property to someone else, they need to reserve certain rights because they own adjacent property, or there's an access issue such that if they were to convey this parcel to someone, then people behind them could be cut off from access to a public street. Not in New York City, on surveys, a lot of easements, you don't usually see them mapped out, but they certainly can be. And the survey will also show you a lot of other things in terms of encroachments, which we'll get to later, but also just showing where property lines end and how, and if there is access for easements, that's really the picture that allows you to see where the rubber meets the road, in fact.
Right. So one key difference between public mapped streets and unmapped or private streets is this responsibility for maintenance and repairs. But as I was talking to Kelly to get ready for this program, she mentioned a few other things that I found interesting, that she's had people come in and say, why won't the city pave my property? And she gives them a few cautionary notes.
Yeah, we have people come in and they're like, or even phone calls, and they're like, I actually had a phone call a couple months back, and they lived in a community board where DOT was paving. They were, they do their yearly paving program, and they said, they said DOT's, paving. Can I have them pave my street? And I said, well, what street do you live on? And they live on, I think it was like Jackson Place or something like that, and it's unmapped. It's Illinois. I said, it's on a mapped street. I said, you can't have that paved. And they're like, well, why not? And I said, well, it's unmapped, it's privately owned. Well, I don't actually say privately owned, it's unmapped. I said, DOT doesn't expend the funds for those types of streets. And they're like, how do I get them to do that? And then I explained the whole process of, well, you can get it mapped, you can have it dedicated if DOT accepts it. I said, but then you have to have possibly alternate side parking, meters, depending on where you are in the borough. And once I start mentioning those types of things, then all of a sudden they're like, oh, no, I don't like alternate side. I can park my car anywhere at any time or anything like that. But I said, well, then, you can't have. Or they say, oh, but I get garbage picked up. I'm like, okay. I said, then that's a gratis, because you're not supposed to get garbage. You're supposed to bring your garbage to the nearest mapped street, is the rule. But I said, if the garbage truck can fit down your block, I said, then, yay, you get to have garbage pickup, I said. But things like that, they call, I want I want it paved. I got a ticket on the street. How do I beat the ticket? And it's like, okay, you can beat the ticket, write a letter, and we'll say it's not mapped. You can beat the ticket. But then they call us a month later, we want it paved. Well, no, you just had the ticket beat. You can't have both. They always want their cake and eat it too. It doesn't quite work that way.
So be careful what you wish for.
Yeah, exactly.
we have been talking about streets generally, but as was said earlier, part of the street is the sidewalk. So on the map, that sidewalk portion is generally part of the map street, unless it's privately owned. And I just thought it would be helpful if Joe could kind of take us through the streetscape.
Sure. So, as Michael mentioned earlier, the sidewalks are included, the width of the sidewalks are included in the width of the street, except in a few rare cases where the sidewalk is actually located on the abutting property. But for the purposes of our conversation, we've sort of broken it down into the streetscape, is what we call it, into 4 different parts. One is the street bed, another is the street trees, and then the sidewalk. And it's not pictured here, but the sewers and the water main as well, which run under the street bed. DOT is responsible for maintaining the street bed, for curbing the streets, street lights, parking meters, and signage. Department of Parks and Recreation is responsible for all of the trees located on city-owned streets and avenues, and the scope of their maintenance is planting, maintaining, so pruning the trees and things of that nature, and removal. Sewers and water mains are the responsibility of the Department of Environmental Protection. And finally, and this is very important, even though they usually don't own the sidewalk, abutting property owners are responsible for the maintenance. So
That's right.
And
so,
that would include things like shoveling the snow. This is making repairs. This is what Kelly meant by they get tickets because DOT actually goes out and occasionally inspects. And so Mike's going to tell us a little bit more about how those things come up on title.
Yeah, so some of these things are title issues and others aren't. As mentioned, the administrative code requires property owners to maintain the sidewalks in front of their property. That includes, cracks, holes, if one of the squares is not even with the others, et cetera. However, most of the examples in which, you probably see this, especially in tree-lined neighborhoods, is that the street is not at all even and has cracks and has holes, but it's because of the tree that's sitting next to it that's been there for 50 years and the roots of which are pulling up the street. That's one instance where the property owner doesn't really have a responsibility. The Department of Parks and Recreation is responsible not only for the trees, but for the roots of those trees and for damage caused by them. And you're, as a property owner, in fact, not allowed to even touch the roots of trees that are in front of your property. So that's one instance in where the owner is not responsible. This comes up on title because DOT regularly will inspect streets, and if they see that that maintenance is required and hasn't been performed, they'll put a sidewalk notice against the property. A sidewalk notice can be looked up in a Department of Highway search, which a title company or a professional search company could do for you, or anyone could just walk into the county clerk's office and look it up. But it's not something that's currently available online to the public. The import of that sidewalk notice is it's not a fine or a monetary lien or anything, but what it's basically saying is it's putting the property owner on notice that you've got a problem, we're documenting it, and you have to fix it. And if the owner hasn't repaired the defect within 45 days, the Department of Transportation has the right to come in and do the work themselves, which is often what happens. And once they do that, they effectively bill the owner for the work that they did. And if that work isn't, and if the property owner doesn't pay for that work, then that bill will turn into a lien, which will show up on a tax bill. And for title, that's of course important because real estate taxes prime every other lien that will show up on title. So if we see a sidewalk notice, we have to call it out as an exception because we don't know if in the interim between when we first did the search and when the closing actually happens, if DOT has gone out and done anything, and if they have, there could be a lien on the property. And again, this is for maintenance, and it's not a fine or a penalty. It's really just compensation to the city for their self-help. So these aren't huge amounts of money, but it's certainly something that needs to be dealt with. And so if you have a sidewalk notice that you need to have cleared, you either have to have DOT come out and do the work and pay for it, or do it yourself and get the sidewalk notice cleared. extent people have seen this over the course of many years, I'll just note quickly, sidewalk notices used to only be for information only because there was language in the policy jacket that dealt with it as an exclusion from coverage elsewhere, but the newer forms don't have that. So in case anyone's wondering why these are now exceptions where they weren't before. For snow and ice removal, that has nothing to do with title whatsoever, but just for everyone's edification, property owners have the obligation to remove snow and ice within 4 hours of a snowfall ending, but not between 9 p.m. and 7 a.m. in the morning. And unlike sidewalk violations, which can become liens, failure to comply with snow and ice removal requirements, which is really a sanitation code violation, the owner could get a ticket, and that would be an ECD violation, but it's not something that would prime. It's not a lien that would function the same way a tax lien would.
There was some interesting news this morning about these ECB fines. Apparently, the city has $1.5 billion in uncollected ECB fines, and the mayor is proposing a partial amnesty program to incentivize people to pay up. So pay attention if that goes through and you have any clients who might owe a little money. On the other hand, Councilman Callis is proposing that businesses would be putting their licenses and permits at risk if they don't pay these fines, over a certain dollar amount. So the city is focusing on this potential income stream and trying to figure out a way to deal with it. Just sort of like, right there this morning. Moving on. Another street issue that comes up in title involves encroachment by the property owner onto the abutting street or sidewalk. And Mike's going to tell us a little bit about how he handles these.
Sure. So there are various different kinds of encroachments. You can have a situation where the building itself, the walls are actually exceed an owner's property and are on someone else's property or on a public street. In this example, you can see that there's a fire escape that's encroaching onto the sidewalk. And then in that smaller square box, which you probably can't see from where you're sitting.
But you have it in your materials.
But you have it in your materials. That refers to much more minor encroachments. There's security cameras, which, by definition, if they're attached to the wall of a building that's up to the property line, those are going to encroach. The cornice of the roof, things of that nature. From a title perspective, we can provide coverage for some of these things. On an owner's title insurance policy, we can insure an encroachment up to 6 inches for a wall of a building, and so long as it's been there for at least 2 years. And the reason for that is it's fairly common sense. From a policy perspective, you can sort of trust that the building has been in existence for more than a very short period of time, and it's part of the physical structure of the building. It doesn't make sense for anyone, for the city, to actually require someone to come in and remove an entire wall. Even if it could be done. We can give that coverage on a loan policy as well for the same reason. When it comes to other encroachments, there's less we can do for an owner. For minor things, like these security cameras, it's unlikely that the city would come in and require their removal, but they certainly have the right to, and the property owner really doesn't have any right to have that thing there. For fire escapes, there are other code reasons why you don't have to worry about the city coming in and removing it, but again, it's not on your private property, it's encroaching onto the street. Technically, the city could force removal. On a loan policy, we can give a lot greater coverage. And the analysis there is that we're not actually insuring that the right of that thing to be there. On the loan policy, we're insuring the lien of the mortgagee, of the lender, against the property. So their title companies are comfortable taking greater risk for minor encroachments because in order for any of that to actually result in a claim, a bunch of things would have to happen. The city would first of all have to come in and say, you have to remove this. Second, it would have to cause enough of a monetary loss to the property such that the value of the property was impaired to the extent that the property is now worth less than what the property could be sold for foreclosure. And then you'd actually have to have the mortgagee foreclosing on the property. So title companies in general are pretty comfortable taking that risk with respect to those things. Other examples, there's certainly instances in which on an owner's policy for I mean, for much larger projects, certainly there are cases where title companies feel comfortable, given the level of the risk involved relative to the size of the deal, that they would insure minor encroachments. So it's not a hard and fast rule, but in general, it's for owners' policies, it's limited to walls.
We also have this exception. You want to talk a little bit about that? For building in a street bed.
Oh, right. So like the map we were showing before, Metropolitan Avenue, if you had a property that you were either selling or getting a loan on, we would raise this exception, which effectively is acknowledging that a portion of the structure lies within the bed of the street, and that the title company is not taking the risk of any action the city may take as a result.
So let's talk about that building in the bed of a mapped street. Joe, is that even possible?
It is. So if a street is mapped, even if it's privately owned, the owner cannot build in that street without city approval. Section 35 in the New York State General City Law prohibits the issuance of any building permit for a building in the bed of a mapped street unless the Board of Appeals granting variances in that city grants a permit for such development. And if a private property owner in New York City wants to build in the bed of a mapped street on his or her property, he or she must obtain the approval of the Board of Standards and Appeals. As an alternative, the property owners can also undertake to have the street running through their property removed from the city map, which is also difficult as to.
Yikes. So removing a street from the city map is called demapping, and among other things, it requires City Uniform Land Use Review, known as ULURP. So I'm just showing this diagram from city planning of the ULURP process to make very clear that this is a really complex, time-consuming, and expensive process, which of course we handle here at Venable. Before you even get to ULURP, a demapping involves significant interagency research and coordination to figure out what interests and uses are located in the street. Remember, a street is mapped from below the ground all the way up to the sky. So basically, the city agencies have to figure out, is there public use of this street? Are there utilities? Are there other kinds of rights in the street that would have to be addressed going forward if the street is being demapped for, private owner? Is the private owner going to acquire the city-owned facilities that have been built there, sewer, water mains, all that kind of stuff? So it's a really big deal to demap a street, and it doesn't happen particularly often, but it has been known to happen. I know Kelly has mentioned a few examples. If it happens, the applicant may need to grant easements back over the street for access and for utilities. And if there's a city public interest in the bed of the street, there may need to be a discontinuance or closing. So Kelly, can you talk a little bit about the mapping and demapping process?
Yeah, sure. When you're going to demap a street, you, in essence, as a private person doing it, you're taking it off to for the benefit of yourself or your project. A map, you get your people on board, and you go to the city planning, you present your proposal. This is what I want to do. This is how I want to do it. And then the city, you follow the process, and the city meets and they decide, okay, fine, you can do this. And then once everything is said and done, whether it takes 2 or 3 years or 20 years, then in essence your street is now legally off the city map. It's been demapped. But that doesn't mean that it's not physically still there. Because sometimes you're demapping a street, but you still need it as your project. For whatever your project is, you still need the street. An example of that would be 55th Street in Brooklyn between 2nd and 1st and 2nd Avenue. Lutheran Hospital demapped 55th Street to benefit themselves, and they closed off a portion of the street, but the street is still physically there. Other times, a street will be demapped, and the project will actually build over the street, which is why they wanted it demapped. semi-example would be Barclays, the Barclays Center over in Brooklyn. They didn't legally demap the street since it wound up being a combination state and private project, but they built over mapped streets. So they just didn't bother to demap them. But so legally they're still physically on the map, but legally not on the ground.
Right, and the state
so
has
I'm
sorry, I was going to say the state has the power to override that mapping requirement, so they're able to do that without demapping.
Right.
In the meantime, I wouldn't advise driving on them.
Yeah, no, because in essence now those streets, because they were not legally demapped, they become paper streets. Bringing that back around. And then also, two maps, you got your alteration map, and then a lot of times though too, sometimes the city will demap streets to create projects. You know, I know up in the Greenpoint, Williamsburg area, they've demapped some streets for a park project. So those streets are legally no longer on the map, but they're still under the city jurisdiction because they're being used as parkland. They've been transferred over to the Parks Department. So a lot of different things can happen when you demap a street, but legally you're taking it off of the map, and what happens physically is a different story. It could physically still be there, or it could be taken off physically because you've built over it.
So Mike mentioned that the private property owner might be interested in finding out if it owns any portion of the street to acquire those development rights, and Joe's just going to talk a little bit about that issue.
So if a developer has clear title to the street, then that developer also, his rights also include the development rights attributable to the street that he owns. In some instances, the property owner may have the right to use a privately owned unmapped street. However, that does not mean he or she has any ownership rights in the street. Ownership interests are shown in a title report. If a street is owned in common by multiple property owners, no one property owner can use the development rights attributable to the street without an agreement with the other abutting property owners who also have an interest in the street. So to illustrate this, we're going to go back to this map, this tax map behind me. In this situation, the alley is a street shared by the owner, and it's probably clearer in your materials than you can see on the screen, but the alley is a street shared by the owner of the blue property and the owner of the yellow property. And so the owner of the blue property has title to the development rights attributable to the portion of the street that runs through the blue property. And the owner of the yellow property has title to the development rights attributable to the portion of the street that runs through the yellow property. So that's pretty much how they break down.
So this is an example of a property, two large parcels that actually have access from surrounding public mapped streets. So they don't rely on that alley for legal access to the property. And that was a question that we've put to Joe. You know, what happens if a development parcel has access only through a private unmapped street or private unmapped easement? What are the implications of that?
Right. So the access issue, it's not that much of an issue in Manhattan necessarily, but in the outer boroughs it does come up, and we've had a few clients that had questions arise about it. But in that case, the owner would be required to comply with certain frontage and access requirements. Under the New York State General City Law, Section 36, no certificate of occupancy can be issued unless a street or highway giving access to such a structure has been placed on the official map. However, like the development in the bed of a mapped street, in New York City, the BSA has the authority to allow a building which is either not located on a mapped street or is located on a mapped street which does not provide access to such building to be built. Any development on property abutting the privately owned unmapped street must also comply with certain provisions of the building code and the fire code. Under the building code, buildings not fronting on a street are required to have a frontage area accessible from a street by a driveway, lane, private road, or alley at least 20 feet wide. And the fire code requires that property not fronting on a public street be accessible from the public street by a 34-foot wide fire apparatus access road. If the fire apparatus access road is less than 34 feet wide, the building shall be protected throughout by a sprinkler system.
So this access question, yep. Have you seen that come up where it was mapped and privately owned?
I haven't seen that come up, but I wouldn't imagine it would make a difference.
Be any different,
I mean, zoning rights run with ownership, so I think a developer can certainly make the case.
Yeah. You wouldn't be able to build in the mapped portion. I'm sorry, did you? No, okay. Okay, so we are going to shift now to talking about how these access issues might come up on title, and, you know, I don't know if you see them.
Yeah, we do. I mean, not very often in Manhattan, as Joe mentioned, but it certainly happens, and they're pretty readily apparent. I mean, you'll see from as soon as you look at a tax map or, better yet, a survey, what access the property has to a public street, and if it doesn't, whether there are alleyways adjoining it, and if you see that, then you've got to start running through the documents that show up on title to find the agreements where those rights of access are codified. One thing that does come up with respect to Manhattan properties more often that relates to alleyways isn't so much about access, but you have situations where you've got a property owner that has this alley next to it, and there's questions about whether those development rights are usable, where the property line ends. Does someone else have the rights to use that alleyway for their access or an egress, and and how that impacts then that developer's plans to redevelop the site? Can we actually go up to the property line, or do I now have a setback because I'm on a burdened parcel for which the benefits runs to my neighbor? That stuff certainly comes up quite a bit, especially these days when property prices being what they are and people trying to build whatever they can wherever they can. And so we would want to make sure that there is in fact a valid easement there, and that's something that we can ensure along with the legal description. We'd run through the meets and bounds description, and you'd say together with the benefits of and subject to the burdens of said easement, whether it's in a separate easement agreement or in a deed or what have you.
Great, thank you. So, as was mentioned above, if the city owns the street, the city owns everything, including the development rights. Streets are inalienable property of the city under the charter, which means the city can't transfer a real property interest without state authorizing legislation. However, every day you walk down the street and you see different kinds of private uses of city-owned streets. So obviously the city can grant some kinds of rights, and we're going to address 4 principal kinds of rights here. We don't have a lot of time to cover them in detail, but Joe's going to give an overview of the nature of those rights, which city agency or agencies have jurisdiction, and a little bit about the application approval process. So why don't we start with vaults?
Okay, so generally vaults they have to be approved by the Department of Transportation. That responsibility is for any street vault, any opening below the surface of the street and outside the property lines that is covered over. The certain things that appear to meet that definition are not considered vaults under the purview of DOT. They include openings that are used exclusively as places for egress or ingress via steps to the basement of a building, openings used primarily for light ventilation, openings constructed and maintained by utility companies, and subways and other structures controlled by a public authority. As part of the application for a license or permit for the construction of a new vault or enlargement of an existing vault, DOT requires that the applicant include a copy of the plan approved by the Department of Buildings, as well as the license agreement filed with DOT's Division of Franchises, Concessions, and Consents. All vault work on vaults in historic districts must receive the approval of the Landmarks Preservation Commission, and vaults near subways and tunnel entrances may require the approval of the MTA. And it's also important to note that if a vault, the applicant must seek a revocable consent from DOT for the construction of any vault that extends beyond the curb line of a street. So I'll discuss a little bit more about that shortly.
But Mike's going to tell us a little bit about the change in how they deal with vaults and vault charges.
Yeah, so from a title perspective, vaults really aren't much of an issue anymore. At a certain point, the city separately assessed them, and in fact, in the 80s, tried to really do an inventory of the vaults that it had and tried to impose greater assessments for people whose vaults they had on record as being much smaller than they actually were. That didn't last very long, and I think even before 1990, they stopped doing that. So now vaults are not separately assessed; they're just part of the property, and from a title perspective, they're not something that's insurable because they, by definition, are on the other side of an owner's property line. To the extent anyone, by the way, doesn't know what we're talking about, the places people would normally see street vaults is in front of just about every retail location on every block in any borough. It's those two steel doors that pop open and people go down and put deliveries in. There are, of course, others that Joe mentioned, but that's where they're most commonly seen. And yes, so again, from a title perspective, street vaults are really not very relevant. If you've got a property where the use is dependent on access to a street vault, or some things we'll talk about later, like sidewalk cafes and things like that, you may want to dig a little deeper, and there are ways to actually search certainly the search of the property would turn up if there's anything recorded against the property that gives the owner rights to use any portion of the street. But also there's a general lot search that can be done that will search anything that's recorded against any street within a tax block, and documents show up there as well, such as revocable consent and whatnot.
Great. So Joe, next, what's the deal with street furniture? Does that mean a sidewalk cafe?
The term street furniture doesn't simply refer to benches, chairs, tables, and for instance, sidewalk cafes require a specific license from the Department of Consumer Affairs. Restaurant owners and managers may apply to the Department of Consumer Affairs for a license to operate a sidewalk cafe on the portion of the sidewalk immediately adjacent to the restaurant premises. As part of that application process, restaurant owners and operators must also confirm that the proposed sidewalk cafe is permitted under the zoning resolution, and that the distance from the property line to the curb is at least 12 feet wide for the entire length of the proposed cafe. Additionally, an applicant must submit an owner's consent and must provide evidence that all required parties have been notified, and notifications must invite all interested parties to the required parties to forward their comments to the community board. And I believe, Kelly, does your office play a role?
Yes, our office, we receive all of the DOT's submissions for both sidewalk cafes and revocable consents. And basically, I just review to make sure that the city does have title to those streets that the people wish to place whatever they need to place on there.
So sidewalk cafes can be a real community issue, and so sometimes you see, in fact, there was recently a case where the owner refused to consent to the restaurant tour renewing or extending that sidewalk cafe. So that can be a real issue. And also sometimes the city council members will get involved and call it up to the council. So it, for what might seem like kind of it's a Department of Consumer Affairs easy permit process, not so easy.
And there are different categories of sidewalk cafes and what the approval process is for an enclosed versus unenclosed sidewalk cafe.
But that's where you go.
Yeah.
So back to street furniture.
Back to street furniture. So street furniture also refers to, generally in the parlance, refers to bus shelters, newsstands, covered bike racks, and automatic public bathrooms, which I have not seen many of. I don't know if anyone else has. But I'm sure you've noticed over the years that the bus shelters and newsstands have been replaced by these metal and glass structures. And that's the byproduct of something called a franchise agreement. A franchise is the grant of the right to occupy or use the city's inalienable property, such as streets or parks, for public service. So in 2005, DOT and a Spanish street furniture company named Musa entered into a franchise agreement under which Musa would design, manufacture, install, and improve these structures at no cost to the city in exchange for having the right to sell advertising on the structures. So that was pretty cool. And the implementation of that plan is still ongoing.
Great. And then the last piece he's going to touch on is the revocable consent process with DOT.
Right. So a revocable consent is the grant of a right to an individual organization to construct and maintain certain structures on, over, and under the inalienable property of the city. So that's streets and sidewalks in a lot of cases. Generally, the revocable consents are granted for a term of 10 years, at the end of which time they may be renewed. As the name implies, the city retains the right to revoke a revocable consent at any time. Revocable consents are required for a wide range of private of improvements, including benches, planters, security bollards, and even below-ground tunnels between two privately owned structures. It's important to note that pursuant to the rules of the city, the approval process and annual fees vary depending on the type of improvement for which the consent is being sought. For improvements that do not meet the locational or dimensional standards outlined in the rules, DOT is required to submit petitions for those improvements to the Department of City Planning to determine whether or not the proposed consent has land use impacts or implications and whether ULURP applies. And for certain improvements such as bridges, guard booths, and security and the information kiosks, DOT must submit those petitions to the Department of City Planning as a matter of course. And one thing that you might think is the subject of revocable consent for DOT, because it goes under street beds and under sidewalks and things of that nature, are telecommunications wires. And they are, while they're subject to the review of DOT and Department of City Planning, they are mostly handled by the Department of Information Technology and Telecommunications. And DOT has this Streetworks manual, which regulates all work being done in city streets, and that those telecommunications work that falls under that umbrella as well.
And again, you may not be finding a revocable consent may be easier said than done. You may have to go to a multitude of places, whether it's consumer affairs or doing a property search, because they're not always recorded against the property, and they're not always recorded against the street in front of the property. And one other place where you will see revocable consents, which Kelly and I were just talking about before the panel, in neighborhoods, less so in Manhattan, but brownstone neighborhoods and Carroll Gardens and Cobble Hill and Park Slope, for example, in Brooklyn, every stoop is effectively on city property, and the city has the right to come in and remove it. And again, politically, obviously very unlikely to happen. But to the extent you have a vacant lot in one of those neighborhoods and want to put a stoop on your property, you're technically not allowed to, because it's city property and DOB won't let you, absent getting the Department of Transportation's permission, which would be given through a revocable consent.
So a revocable consent is a license and not an interest in real property, which is why the city can grant those kinds of interests. But it actually, that discussion is perhaps explains why the hospital that Kelly mentioned undertook a demapping process, because in order to invest the kind of money that they must have needed to invest to build a building over what was a street, they wouldn't necessarily want to do that or be able to get financing to do it on the basis of a revocable license. So in order to acquire a real property interest, the street would have to be, they'd have to go through that whole process in order to do that. So there we have it. I think we're almost out of time. I want to leave some time for questions, so we're going to wrap up now, and I did want to say that the list of questions about streets that we did not address today is much longer than what we were able to address. So I'm sure you have a few questions, and there could be things that you think of later, but our contact info is in the materials. We hope at least that we've provided you with a baseline and some ideas for what to look for, where to go to find information, who to ask. And with that, I just want to thank Joe, Mike, and Kelly for sharing their insights and experience with us today. And we have a few minutes, so anybody have any questions?
Well, technically, a paper street doesn't physically exist. Yeah, so it depends on what they're going to build in the sense of the development. Well, okay, but if it, even though there's nothing physically there, I guess since it is a mapped street, they could build only up to that property line.
Right, and I guess the question relates to whether or not in that type of case, if it's a city-owned mapped street that just doesn't physically exist, if the developer wants to build in order to get that access that Joe was talking about, would the city be obligated to come in and build the street? Is that kind of where you're going with the question? Or would the city impose that obligation on the developer?
Well, they might. I guess it would depend, again, what they're building, what the requirements are from the Department of Buildings. They might, and what DOT is, because they might have to do a builder's permit, a builder's pavement plan to show, because if that area somehow connects to the street and it's below grade and stuff, they might make you raise it to legal grade.
Right, and if it's done in the context of a public approval process where, there's some discretionary city approval, that could be the kind of thing that is imposed as a condition, but I would say that's it's probably not that common, so maybe a case-by-case basis.
Yeah.
Yeah, go ahead.
Appreciate very much what you're saying. There's an expression that I heard to as a marginal.
Yeah, marginal streets are usually near the water, and they can be mapped. They can be demapped. It all depends on what you're building and how it's going to affect the nearby area, and if what is there street-wise or map-wise, but not physical, if it's going to affect something, and if the city says, oh no, now you have to build more, you have to build less, this has to be taken into account. So a lot depends on what you're doing, what your plan is and your proposal.
And where I've seen those, they have come up kind of where they're adjacent to or running alongside another street, and maybe they aren't in their own right kind of the size and nature that DOT would consider to be, street worthy.
Yeah.
If a map of unbuilt street can take part of that?
That's more of a zoning issue, in the sense, taking what's above. I only deal with streets out there, down here. I don't. It's more zoning, and again, everything goes back to what are you building, and how do you want to build it? Do you need to take, the air rights above it and stuff like that?
I'm thinking you need legal windows.
Yeah, I mean, again, it goes back to the zoning regulations. You have to see what it's zoned for, and then, again, your proposal and how it might affect. It might benefit you to not take the air rights, this way over the street, and take them over the buildings surrounding you instead, or something like that.
Right, but it would depend, I guess, if it's a mapped street. even though it doesn't physically exist, whether it meets the definition of street under the building code, right, how they would look at it. It would meet the definition, I think it would meet the definition under the zoning resolution because it's mapped.
Yeah.
And so how DOB would look under it, under their definition for their code purposes. But, you know, if it's a mapped street, it's a street, so.
Do you know if the ownership factor on it, privately owned versus?
Oh, well, yeah, I mean, if it's privately owned, you would need a development rights agreement with the adjacent landowner. I think your first question, I think we could sort of say without knowing the nitty-gritty of the zoning law, that it should be okay because if it is a mapped street, it's owned by the city, and, you know, by definition, the city is not going to build on it or convey it to a private developer. So there will, in fact, always be that light and air.
Right.
In terms of liability, sidewalks, you can remove the snow like the sidewalk for hours. Is that the city liability or is it the property owner? And is it based on whether you have a sidewalk fee or a sidewalk violation, or is it at any time anything happens on the sidewalk?
You brought up a few different things. It's okay. So you're saying if you didn't clear the snow and someone tripped and fell?
Yes. Assume you didn't clear the snow or someone tripped and fell within the 4-hour window. Two different scenarios, but is there a differentiation of where liability would fall in?
That's a good question. Not in my wheelhouse. I would guess that, well, first of all, the person who fell, I guarantee you, will sue everyone,
Right.
including probably the people attending the CLE. But I don't think that you don't have liability vis-a-vis the city or Department of Sanitation if you're within those rules. A private party, I think, can sue anyone, and it's just, I guess it would just be a standard test for negligence given the circumstances. A sidewalk notice, which wouldn't be for snow and ice, that's more for if you've got a cracked sidewalk or an uneven sidewalk. There, certainly, you have the obligation to repair the sidewalk in front of your street, and you would certainly be liable.
So that depends on what kind of street they're bridging over. If it's a city street, then it would be a revocable consent through DOT. If it's on property that is subject to some state public authority jurisdiction, it would, you know, obviously would be it would come up under the state law. For the West Side Highway and West Street down there, that's a state highway, so that's not a city process to get that approval, but there's a separate state process to get that approval for the bridges that go from like the World Trade Center over to Battery Park City. Dan?
Well, the only time we show easements on our maps are sewer easements. You know, if we've demapped the street and they've kept the existing sewer that's there, and so they need access to it. Other than that, we don't actually show any kind of underground easements. You know, I mean, it'll show, tax map would show it. So there's got to be some kind of recording.
Yeah, if it doesn't benefit or burden the adjacent properties, and therefore by definition doesn't really affect them, I would guess it wouldn't be recorded against those lots. It certainly could be, but it would be recorded against lot 9999 within the tax block. As I was mentioning before, you can actually search on Acris. You put in the block, whatever block it is, and 9999, and it'll pull up everything that's recorded against all of the streets within that tax block. And it's not very many documents.
Yeah, I tried searching a few and nothing came up.
Yeah.
Yes.
Yes.
Under what circumstances might they?
Well, I think the city's probably looking for two things, right? One, they're very concerned about environmental conditions and not taking title and becoming liable for those. And then second, I think they're probably only interested in streets that have enough public use and enough kind of public investment to make it worth their while to take it over. So if it's, used really a private street that's used only to access a few homes, then the city might not be interested in taking the title to it and taking over the responsibility. Talk to DOT. Okay. So a state public authority of some kind, like the Urban Development Corporation, if they actually owned a site and wanted to somehow take over a part of the adjacent street. Right, so that would require a legislative search to find that, but there could be a law specifically about those streets, or there could be some authorizing language in the public authorities authorizing legislation that gives them certain powers, and then depending on what it says, would determine what the process is. By those streets. Well, different state public authorities have different types of powers to override local procedures. They can't override the state laws, obviously, but there's some flexibility there in terms of what they can do. It may be that this question is very specific. We've seen different kinds of circumstances in which state authorities are taking over city streets for different kinds of purposes, or relocating city streets, reconfiguring, that sort of thing. For example, what's happening down at the World Trade Center with the new plan. But I would imagine that's probably very specific to the individual case. Yep.
We don't show that distinction. Basically, the streets are owned by the city of New York. You would have to know, like, the highways are state, some highways are state, some are city. But we don't show a distinction between city and state, or park department and DOT. So
it wouldn't necessarily show up on the city's map.
No.
Probably one way is that the signage is going to be a little different, like there's some indications. You may also be able to find out on regular maps if they refer to it as a state highway, at least to give you a clue. But to confirm, I guess that would be either a city or a state DOT question in terms of researching it. Anything else? Okay, well, I want to thank our panelists for coming, and if you're just remind everybody, if you're signed up for CLE credits, make sure that you've signed in, and please fill out the evaluations. I'd also like to just announce that we have another event scheduled for July. John Banks, the incoming president of REBNY, the Real Estate Board of New York, will be here for a breakfast conversation with one of our partners, Gordon Davis. Mr. Banks was formerly the VP of Government Relations at Con Ed, and he's been essentially kind of training for the job to take over starting in July at REBNY. So a few hot issues that he's been coming up to speed on, and some things he's planning to talk about could include the recent moratorium on the conversion of hotels to luxury residential condos, the increased presence of Airbnb in the city, and the 421A rent regulation issues that are all going on, which will hopefully be resolved before he comes to speak. Right. So if you want to register for that, we have a sign-up sheet out front, so we'll send you the invitation. You're obviously on our list, so you can also look for the email and register when it comes. We hope to see you. Thank you all for coming.
And thank you very much to Susan Golden and to Venable for hosting us today.